Hello, welcome to this FieldFisher webinar in which we will update you on the most recent EU cybersecurity regulations. I am Tim van Kanijts, partner in the Tech and Data team of FieldFisher Brussels, and I'm joined today by Louis van der Dongt, associates in our team. So what do we have on the menu? Well, Louis will first discuss the recently adopted NIS2 directive. I will then walk you through the Digital Operational Resilience Act, DORA, and finally I will say a few words about the proposal for a Cyber Resilience Act, also known under the acronym CRA. And with that, I hand over to you, Louis.
Right, thank you, Tim, for that introduction. All right, so the NIS2 directive. I'll get right to it because there's quite a lot to unpack. So if we move on to the next slide, we look at what the objectives are. Does it apply to you? And if so, what are your obligations? And what happens if you don't comply? Those are the questions I'll try to answer in the upcoming half hour. So let's start off with the context in which the directive came about. As the name suggests, the NIS2 directive follows up the first NIS directive. The overall objective of both directives is to improve resilience and incident response capacities of public and private sectors. The NIS2 directive imposes a range of obligations on both member states and organizations. During this webinar, we will focus on the obligations imposed on organizations. There's a whole part of the directive on specific obligations for member states, for example, on national cybersecurity strategies, the obligations to set up a national cyber management framework, etc. These member states' obligations are not the focus of today's presentation, so we'll look at the obligations and considerations for organizations under the directive. The NIS2 directive entered into force on the 16th of January this year, and as it is a directive, it needs to be transposed into national law. Member states have 21 months to do this, that is until the 17th of October 2024. For the first NIS directive, there were quite some member states that did not meet the deadline, so in any case, it's worth monitoring in your local jurisdiction what the status is on that. Quite an important remark, the NIS2 directive sets a horizontal base layer of cybersecurity obligations. As we'll see later, it applies to a whole range of services and sectors. There are additional layers of cybersecurity law that apply to specific services and sectors. I'm thinking about telecommunications sectors with its own cybersecurity laws, trust service, and the likes. Where those sector-specific laws require organizations to adopt equivalent cybersecurity risk management measures or incident response obligations, these notifications will prevail over NIS2. Supervision and enforcement will then also be dealt with in those sector-specific acts. All right, so if we move on to the next slide, please, where we will discuss the scope and the key concepts. One of the most important questions at this stage is to assess whether NIS2 will apply to your organization. There are three conditions for NIS2 to be applicable. Firstly, you must provide a service that falls within one of the sectors listed in the annexes of the directive. So the directive contains two annexes with a list of sectors and specific subsectors. The first annex lists the so-called sectors of high criticality. The second annex lists the so-called other critical sectors. Secondly, you must provide those services from the annexes within the EU. The first two conditions must be met cumulatively. And then as a third condition, there is a size cap rule. If you meet or exceed the thresholds to qualify as a medium-sized enterprise, you fall in scope of the NIS2 directive. Just as a reminder, you qualify as a medium-sized enterprise if you employ more than 50 employees and have an annual turnover or annual balance sheet total of exceeding 10 million euros. If you don't meet this threshold, you can still fall under NIS2 if you fulfill one of the other conditions listed on the right-hand side of the slide. So it's a bit complex, but to recap, if you're a medium-sized or large enterprise and you provide one of the services listed in the annexes of directive in the EU, you're caught under the scope of NIS2. If you're micro-sized or small and providing one of the services in the annexes of the directive, you may fall under the scope based on one of the points on the right-hand side of the slide. All right, so what are the sectors that I've been referring to? On the next slide, you see that we've set them out in an overview. And as you can see, the NIS2 directive covers all the sectors previously caught under the first NIS directive, as well as 11 new sectors. Within each of these broad industry sectors, the NIS2 directive specifies the relevant subsectors which are also within scope. For example, we see that manufacturing is added as a sector, but this covers subsectors of manufacturing medical devices, motor vehicles, electrical equipment, and more. Now, the important takeaway of the slide is that there is a lot of new sectors. As such, the NIS2 directive has a significantly larger scope than its predecessor. An early estimate by the Belgian Center for Cybersecurity suggested that there would be 20 to 40-fold increase in the scope of entities under NIS2 versus NIS1. It's especially relevant to know for these new companies that now fall under the scope of NIS2. As we'll see, there's quite a lot of obligations and requirements to fulfill under the directive. So even though there's still some time before member states have to transpose the directive, it's definitely not bad to start considering your position under NIS2 already today. All right, on the next slide, we will talk about the distinction between essential and important entities. So you've determined that you fall within scope of the directive. The next step would be to assess whether you are either essential or an important entity. The distinction is important as different regimes apply to essential entities and important entities in terms of supervision and potential sanctions. Now we'll point out these differences when we talk about those topics. Unfortunately, in some cases, it's not that easy to identify whether a particular organization would constitute an essential or an important entity, especially because defining essential entities is in some instances left to the individual member states. But leaving out the member state discretion, it's already clear that medium-sized enterprises or larger that have an activity under a sector of high criticality, so the Annex 1 that I referred to, those entities will qualify as essential entities. Same goes for those entities that we've listed on the top-hand side of the slide. Important entities would be the residual category of entities that fall within scope of the NIS2 directive, but that are not essential entities, or entities that are specifically identified by the member state as being an important entity. All right, so what member state law would apply? On the next slide, we'll look into that specific topic. Now, as I said in the beginning of the presentation, it's now up to member states to implement NIS2 directive into national law. This will mean 27 implementations into national law. As was the case under the first NIS directive, there can be some variation in the way member states will implement the directive. Therefore, understanding which member state law will apply to you will be important. Generally speaking, entities will fall under the jurisdiction of the member state where they have an establishment. This means that organizations with establishments in multiple member states will have to abide by the laws implemented in each jurisdiction where they have an establishment. There are exceptions to this rule for public electronic communications networks and service providers, as well as public administration entities. And these exceptions are on the slide. Now I'd like to look directly at the third point on the slide, which refers to the specific regime that applies to those services that are typically cross-border. And we'll look at those in the next slide. So thank you. All right. So member state law that applies to these services is that of the place of main establishment. These cross-border services are the former digital services providers, or the DSPs under NIS1. So your cloud computing service providers, data center service providers, as well as your online marketplaces, online search engines, or social networking services platforms. And an exhaustive list of these cross-border services is included in the directive. The rules that apply to these types of services are a bit comparable to what we see under the GDPR. So we're working again with the notion of the main establishment. To determine which country is that of the main establishment, we first look at where the decision-making process is centered. If that's not in the EU, or if it's not possible to determine this, you look at the member state where cybersecurity operations are centralized. If that member state cannot be determined either, you will have a look at the member state with the highest number of employees. If your entity does not have an establishment in the EU, you need to appoint an EU representative, much as the same as you would have to do under the GDPR. And then it will be the country law of where you place that representative that would apply. All right, so moving on to the next slide, please. So you've established that the NIS2 directive applies to you. You know whether you're an essential or an important entity, and you know what member state law applies. The next question then would be, what are your obligations under NIS2? On this slide, we have an overview of some of the key changes under the new directive. And I'll walk you through each of these points. All right, so on the next slide, we'll look at the cybersecurity risk management measures. First off, you need to put in place appropriate and proportionate technical and organizational measures to manage risks to the functioning of network and information systems that you use in your operations or to provide your services. And you need to implement those measures to prevent or minimize the impact of incidents. The measures should be appropriate and proportionate. In other words, you should take into account the state of the art, relevant EU and international standards, the cost of implementation, your risk exposure, and your size as an organization. The minimum type of measure set out in the directive are actually standard security practice, but now codified into law. So you need to foresee security of your systems and facilities. You need to have an incident handling process in place, have processes in place to ensure your business continuity, and you need to regularly monitor, audit, and test whatever you have put in place. All right, so in the next slide, please, we'll have a look at the supply chain security diligence. So you need to have a look at the supply chain security and your supplier relationships under NIS2. You need to consider cyber resilience of your suppliers and service providers. Organizations should assess the vulnerabilities specific to each direct supplier and service provider, as well as the overall quality of products and cybersecurity of these suppliers. And so on this basis, you must flow down your security standards on these suppliers and service providers. Practically speaking, covered entities will have to perform third-party security assessments and incorporate appropriate security requirements in your third-party contracts. You'll note that I said direct suppliers and service providers. So the obligation does not go all the way down the chain of suppliers. In that regard, the recital states that covered entities, and I'm paraphrasing, could consider risks stemming from other levels of suppliers and service providers. A small side note here, the directive departs from a minimum harmonization, so member states can set up more elaborate obligations. It's also worth checking then in the implementing laws whether you are required to go further than your direct suppliers and service providers. All right, so let's have a look at the next slide, please. So on incident reporting. The reporting obligations have been streamlined in NIS2 with more precise obligations regarding the process, the contents of the notifications, and the timeline within which incident must be reported. There's now a notification obligation for significant incidents. So what is a significant incident? An incident is an event compromising confidentiality, integrity, availability, but also authenticity of your data or services. Significant means that it can cause or has caused severe operational disruption or financial loss, or has caused others severe material or non-material damage. For such incidents, you have a three-tiered notification obligation. First off, there's an early warning requirement within 24 hours of becoming aware of the incident. This early warning only needs to contain basic information, whether it was a malicious or accidental incident, and whether it has had a cross-border impact. Then an incident notification should fall within 72 hours of becoming aware. That's an update of the initial report with more information on the incident, so on the severity, the impact, etc. And then a final report within 1 month of the incident notification. So that's not from the early warning, but from the incident notification. Okay, so let's have a look at the next slide, please, which is new under NIS2. It's on the management responsibility under NIS2. Management bodies of essential and important entities are required to explicitly approve and oversee the implementation of risk management measures required under the directive. In addition, members of those management bodies will have to undertake cybersecurity training. This training should allow them to properly identify risks and assess cybersecurity risk management practices and their impact on services provided by their organization. If a company does not comply with its NIS2 obligations, management can be held personally liable. In addition, for essential entities, supervisory authorities can in some circumstances even impose a temporary prohibition of the exercise of managerial functions by any person at a chief executive officer or legal representative level. All right, on the next slide, please, we'll have a look at supervision and sanctions. I admit there's a lot of information on the slide. It's an overview of the options that supervisory authorities must at least have to supervise and enforce the directive. I say at least because member states can add to this list measures that are effective, proportionate, and dissuasive. The point of this overview is to show that supervisory authorities will be granted a lot more powers compared to the NIS directive. And to be fair, enforcement of the NIS directive was very low, especially if you compare it with the enforcement we have seen so far with the GDPR. So with the NIS2 directive, it is quite likely that this will change in the future. Okay, so on the slide, you see the difference between essential and important entities. Important entities are subject to a light ex-post supervisory regime. Audits can be conducted after a certain non-compliance has transpired. Essential entities may be subject to both an ex-post measure as well as ex-ante preventative measures to ensure compliance. Then the type of sanctions that can be imposed are also more elaborate for essential entities. And then finally, for financial penalties, important entities can be subject to penalties of the higher amount of 7 million euros or 1.4% of global annual turnover, whereas for essential entities, that's the higher amount of 10 million euros or 2% of global annual turnover. All right, so on the final side on my part, what can organizations already start doing? The first question will be to assess whether you're covered by NIS2. So for medium-sized and larger companies that provide one of the services in the annexes within the EU, it's already clear that they will be covered. However, smaller companies in one of those sectors should also assess whether they fall in scope of the NIS2 directive. And then if you consider that you do fall in scope, you need to assess what technical organizational measures are appropriate and proportionate. Another important point is to start reviewing your contractual arrangements with your direct suppliers and service providers. We expect that this repapering exercise may take up a lot of time and work. On this point, if you're a service provider for an entity falling in scope of NIS2, know that this repapering exercise may also be something that you can anticipate and prepare for. And then the next point on the slide, if you fall in scope, you may already need to set aside budget for implementing the requirements of NIS2. According to the EU, companies which were already subject to the NIS1 directive should expect an increase of up to 12% in their ICT spend for the years immediately following the implementation of the NIS2 directive. For companies which were not yet subject to the NIS1 directive, the estimate is a 22% increase in ICT spend. And then a last point, compliance with the requirements in the NIS2 directive will require staff at all levels in your organization to be cyber aware, and it goes from management down. That means that you have to start training your staff on cyber awareness. And with that, I'll leave the floor to Tim, who will fill you in on the Digital Operational Resilience Act and the Cyber Resilience Act.
Thank you, Louis. DORA, what is it about? Well, in essence, DORA aims at achieving a so-called high common level of digital operational resilience for the financial sector. And as the recitals rightly indicate, the use of ICT has acquired a critical importance in the operation of the typical daily functions of all financial entities. And so ICT risk must be appropriately managed to ensure this digital operational resilience of financial institutions. Now, what does it mean exactly, digital operational resilience? Well, it is described as the ability of a financial entity to build, assure, and review its operational integrity and reliability to ensure the security of the IT systems that it uses. And this resilience must be supported, or must support rather, the continued provision of financial services and their quality, also in case of disruptions. And DORA expects to achieve this resilience by imposing a series of detailed obligations in various areas. So there's, first of all, ICT risk management. I'll come back to that point specifically. There's also ICT-related incident management, classification, and reporting. These are specific reporting obligations. As Louis said, NIS2 is the general cybersecurity law. DORA is a more specific one, and so more specific incident reporting obligations are foreseen in DORA. I'll also come back to that in a couple of minutes. DORA also covers the obligations around digital operational resilience testing, which includes penetration testing. And there is a very important chapter around ICT third-party risk management. Obviously, it's, as you will hopefully understand, insufficient to address the ICT risk within the organization, because it's also important that the ICT providers of the financial service sector contribute to it. And so what DORA does is it imposes a series of measures and required contractual obligations. And if you are familiar with the outsourcing guidelines for the financial sector, this is something that will look quite familiar to you. And then finally, there is also an encouragement of financial institutions to share information between them on cyber threats, so knowledge and information sharing. Okay, so the big question then is, who is covered by the material scope of DORA? And if we look at Article 2, it actually contains a long list of all kinds of entities that are active in the financial sector, which goes from the very obvious usual suspects, credits institutions, payment institutions, but also CSDs, insurance, reinsurance companies, and it even covers crypto asset agencies, credit rating agencies, etc. So a very broad scope. However, it's not only financial entities who are caught. Many obligations will indirectly impact ICT service providers, for instance, in terms of contractual requirements. And more importantly, the so-called critical ICT service providers are subject to specific legal obligations under DORA. Okay, with that said, let's look a bit closer at what the expectations are around ICT risk management. In essence, financial entities must implement a sound and comprehensive ICT risk management framework. And in principle, a lot will or should already exist within these organizations, but adaptations and tweaks will be needed in different areas. And as part of their framework the financial entities must ensure that they use and maintain updated and resilient ICT systems. So they must identify and classify their ICT assets, they must implement continuous monitoring of their systems, and they must be able to detect anomalous activity promptly. To minimize the impact of incidents, there are specific obligations around having a business continuity policy, disaster recovery plans, and backup and restoration procedures, all of which should sound familiar. Furthermore, they must conduct ex-ante vulnerability analyses and ex-post reviews following an ICT incident, and they must have crisis communication plans. So all these obligations are subject to the overarching proportionality principle, and this allows them to determine the measures they implement to taking into account the risk, but also their size. And what I think is good to know is that there are a number of financial entities who only need to comply with simplified ICT risk management requirements, especially if they are a bit smaller. Okay, so as I said, like NIS2, DORA also contains reporting obligations. Now, the reporting obligations under DORA are triggered by so-called major ICT-related incidents or major operational or security payment-related incidents. That's quite a mouthful, I know. Okay, so these incidents, they quite resemble the so-called significant incident concept under NIS2, but they're not fully identical. In essence, if you look at the definitions, they are unplanned events that compromise the security of a network, which may result in a high adverse impact. And again, as it is the case under NIS2, DORA proceeds 3 layers of notifications. But it leaves it up to the European supervisory authorities to adopt the time limits to notify an incident. So that's a bit of a difference with NIS2. If the incident may have a financial impact on a client, financial entity must also notify the clients. And then finally, and it's not on this slide, but you should know that DORA also allows financial entities to report significant cyber threats on a voluntary basis. So let me then say a few words about the impact of DORA on ICT service providers. And I think this is really one of the key developments and innovations that DORA will bring. So the ESAs, the European Banking Authority, European Securities and Markets Authority, and European Insurance and Occupational Pensions Authority, so those 3 combined referred to as the ESAs, they have the power to designate ICT service providers which they consider to be critical. And that will be driven, for instance, by the fact that the failure of such a provider to deliver its ICT services might have a systemic impact on the financial system. So these critical ICT service providers will be subject to the regulatory oversight of a lead overseer who will assess whether they have themselves comprehensive procedures to manage ICT risk. And that will obviously be quite a game changer for those ICT service providers who will be designated as being critical. So what does all this mean in terms of sanctions? Well, DORA doesn't specify administrative fines, but leaves it to the member states to foresee the so-called appropriate administrative penalties, and those may obviously include fines. In relation specifically to critical ICT providers, DORA foresees broad enforcement powers for the lead overseer, including the possibility to impose daily penalty payments. And the enforcement of the critical ICT providers will be funded by an oversight fee that critical ICT providers will have to pay. So that's also well, something which they will likely not be very happy about. Anyway, obviously that's enforcement. What are the next steps? Well, DORA has been adopted, but in terms of the rules becoming applicable, they will become applicable in a bit less than 2 years on the 17th of January 2025. And that brings us to the last topic of this webinar, which is the Cyber Resilience Act. Now, unlike NIS2 and DORA, the CRA currently still is a proposal for regulation, so it hasn't been adopted yet, and therefore is still likely to evolve, which also means that we won't discuss it into too much detail in this webinar. Just give you a bit of a first high-level overview so that you have a basic understanding of what it intends to achieve. And obviously we'll need to follow up as the discussions within the EU institutions progress. Good, well, so good question. And what does it intend to achieve? Basically, the Cyber Resilience Act wants to ensure cybersecurity of products. Products could be hardware or software, but products with digital elements. And it wants to achieve this by imposing rules for the placing of digital products on the EU market. And it will do that by imposing so-called essential cybersecurity requirements on the manufacturers, and also imposing specific requirements around vulnerability handling. So what is then the scope of the CRA? Well, it applies to digital products whose intended use is to directly or indirectly connect to a device or a network. The CRA proposes to exclude a number of specific digital products, quite a long list, but if I would just name a few, the ones that I think are the most interesting to bear in mind, SaaS solutions are excluded, not always, they are excluded, provided they are not an integral part of the remote data processing solution of a digital product. So only in those cases are they not subject to the CRA. Similarly, open source software is not covered by the CRA if it is not developed in the course of a commercial activity. Okay, so let's have a look at the obligations then. And there, what is important to bear in mind is that the CRA classifies digital products in 3 categories. Actually, 90% will be non-critical and will be subject to the lowest level of obligations, and it's mostly about self-assessing cybersecurity vulnerabilities. If we go up one level, we get to critical digital products, and they are themselves ranked in 2 classes, depending, as you can imagine, on the risk. We have class 1, which covers things like identity management software. Class 2 covers operating systems, smart cards, IoT products for essential entities, etc. So the products that bear a higher risk in case of cyber issues. And finally, noteworthy, the Commission also may decide to add an additional category, which is not in the CRA yet, but something that the Commission could decide to add, the so-called highly critical digital products, and those products would be required to obtain a European cybersecurity certificate before being put on the market. All right, so what are the key obligations? Well, the CRA contains different provisions depending on whether a party is the manufacturer, the importer, or the distributor. And as you can imagine, naturally, even I would say most obligations apply to the manufacturers. I won't discuss them all and in detail, but the key elements that are the key elements for manufacturers in terms of obligations is the requirement to comply with the essential cybersecurity requirements. They need to conduct risk assessments, and they need to obtain a CE mark for their digital products before they put them on the market. If we then look at the importers, well, importers essentially need to verify that the manufacturer met the essential cybersecurity requirements and that the users of those products are being provided with the mandatory technical information and instructions. And then finally, if we look at the distributors, they are subject to a much lighter verification requirement, but they may be required to withdraw or recall products from the market if it turns out that the manufacturer does not take corrective measures to address cyber vulnerabilities that have arisen. And I think one important last attention point that I would like to mention here in the context of the obligations relates to white labeling, something which is very common in the IT industry. If an importer or a distributor puts a digital product on the market under its own trademark as a white label, it will need to comply with the obligations as if it were the manufacturer. That's very important to bear in mind. Okay, so what about enforcement then? The CRA, if it would be adopted, intends to combine a mix of EU and member state authority enforcement. and has an administrative sanction mechanism that is actually quite similar to that of GDPR, DSA, and NIS2. And so that includes the possibility to impose administrative fines up to 2.5% of global annual turnover. What are then the next steps? Well, as I mentioned, this is still a proposal. European Parliament and the Council are still debating their negotiation mandate, following which the usual trilogue will kick off, where the three institutions need to find and agree on a compromise text. Obviously, as you can imagine, the Commission is quite keen to land with the CRA before the upcoming European elections in 2024. As it always goes with these kind of trilogues, who knows if that will be feasible? Time will tell, I guess. But what is sure is that if and when adopted, the CRA will be subject to a 2-year transition period. And with that, we have come to the end of this webinar. On this slide, you can see, if you're interested in some further reading, some insight articles that we published on specifically the NIS2 directive. We hope you found this overview of the cybersecurity regulations in the EU useful. Many thanks for attending, and Louis and I look forward to seeing you at our next event. Thank you.